is Shannon Stillwell's lawyer, Mr. Shardt, filing renewed motion for fair and constitutional trial and appropriate remedies for constitutional violations. This is 21 pages. I don't know how much of it. I won't go into exhibits. I will just read the motion. Comes now. Mr. Shannon Stillwell, by and through undersigned counsel, and hereby files this renewed motion for fair and constitutional trial in the above styled case. In support of this motion, Mr. Stillwell shows as follows. 1. Background facts. Mr. Stillwell is accused of multiple felonies, including conspiracy to violate the Georgia RICO law and substantive felonies. Mr. Stillwell is an innocent man. Number 2. This is what I like about how Shardt and Steele and Weinstein, they write so, their motions are easy to translate or to transcribe for you or to read for you. While Ms. Love's absolute horse shit she presents as motions is really hard to read because it's so much bull crap. 2. Like all citizens, Mr. Stillwell is guaranteed a fair trial and due process by the federal and state constitution, the Confrontation Clause, the Due Process Clause, and all other constitutional protections. The 6th and 14th Amendment of the U.S. Constitution guarantee criminal defendants the right to a trial in front of a fair and impartial judge. The Due Process Clause guarantees a defendant a trial free of prosecutorial misconduct. Number 3, Mr. Stillwell and his co-defendants have been in trial for approximately 19 months. Approximately 75 witnesses have testified so far. Yeah, we are officially on witness number 84, but a few of them have testified more than once. Mr. Stillwell has remained in jail for the duration of this trial. 4. Judge Ural Glanville was the original trial judge in this case. Judge Glanville was recused from this case via an order signed by the Honorable Judge Krause on July 15, 2024. Mr. Stillwell's rights. 5. The state is seeking a life without parole sentence for Mr. Stillwell if he is wrongly convicted. Mr. Stillwell demands that his trial be conducted in a fair and constitutional manner. Prosecutional misconduct implicates a criminal defendant's due process rights when it renders a trial unfair and violates the defendant's right to a fair trial. Due process also requires Mr. Stillwell receive a fair trial in front of a fair tribunal. Quote, judicial integrity is a state interest of the highest order because the power and prerogative of a court to resolve disputes rest upon the respect accorded by citizens to a court's judgment, which in turn depend on the issuing court's absolute probity. To the extent this trial has failed to meet these constitutional requirements in the past, Mr. Stillwell demands that this court take appropriate actions. While Mr. Stillwell is confident that the court will endeavor to ensure him a fair trial moving forward from the current trial judge, this does not cure the constitutional errors and the resulting harm to Mr. Stillwell, which has already occurred. Readily apparent examples of error, impropriety, prosecutorial misconduct, and judicial partiality. Here we go, folks. Here we go. This might be a few. Number 6 here. This case has been plagued by discovery violations, lost and missing police reports, and Brady violations. As detailed in depth in co-defendant Williams' July 10, 2024 motions for a fair trial, the prosecutors of this case have repeated failed to follow the orders of the court, have made spacious allegations against defense counsel, and have lacked candor to the court. Number 8. This case has been plagued by improper legal rulings, including, but not limited to, an overly liberal and unconstitutional application of OCGA 801 D2E. Defense counsel has routinely been cut off by the prior trial judge when arguing these matters, and rulings have been made with little or no analysis. Hold on. 9. This case has also been exceptional in the treatment, actually mistreatment, of defendants and defense counsel. Examples include, but are not limited to: A. An incident which occurred on or about October 2nd, 2023, when Judge Glanville initiated a contempt hearing against undersigned counsel Max Shardt, attorney for Mr. Stillwell. On this date, Judge Glanville sent deputies to find undersigned counsel during the court's lunch break and summoned undersigned counsel to chambers. And here's the footnote. Counsel is solely concerned with his client, Mr. Stillwell, and not himself. Nonetheless, the treatment of defense counsel in this case is evidence of Judge Glanville's lack of impartiality throughout this case, which violates Mr. Stillwell's constitutional rights. Let's continue. A courtroom deputy informed undersigned counsel that Judge Glanville was expecting an apology from counsel for calling him, quote-unquote, some bull crap in open court. While in chambers, undersigned counsel was advised that he should not deny the accusation, as it was all captured on video. Let's check the footnotes. Footnote 2. As defense counsel never uttered these words, undersigned counsel is relying on his memory as to what exactly the specific alleged uttered words were. The press was not filming that day, and the transcript is not available to counsel at this time. 3. Obviously, this was not an effective interrogation technique, as undersigned counsel knew that he did not commit said act and would not be shown on courtroom video doing so. Let's continue. When undersigned counsel refused to apologize to something he did not do, Judge Glanville tersely instructed counsel to leave his chambers. Later in the day, Judge Glanville initiated a contempt hearing against undersigned counsel. Judge Glanville berated counsel and threatened incarceration. Okay, this was the example I mentioned really early on. My mistake, I thought this was in a prior case. This is apparently happened in this case. Judge Glanville accused undersigned counsel of violating bar rules and putting his law license in jeopardy for lying to the tribunal and not confessing his sins. Footnote 4. The reality is that the court was demanding that undersigned counsel lie to the tribunal by falsely confessing to something that he did not do. In the end, the attorney, David Bott, who was seated within feet of undersigned counsel at the time, spoke up and stated that undersigned counsel never made such a statement. Of course, the video that, quote-unquote, captured the event was never produced and no apology was made. B. Judge Glanville has repeatedly demanded that certain defense counsel, including but not limited to undersigned counsel, Attorney Brian Steele and Attorney Catherine Matthews, to quote-unquote sit down in a terse and abrupt manner when overruling valid objections, all in front of the jury. These incidents has been too numerous to document individually. Yeah, this has been a pet peeve or whatever. It's been so bad because Judge Glanville demanded of the defense attorneys that only one of them objected and the others should wait for that one to object and not all standing up at the same time, which is completely moronic because Judge Glanville allowed this trial with 6 co-defendants, all with their own counsel. No defense counsel have an interest besides their own defendant, besides their own client. they have a duty to their client to object to anything they deem valid, making valid objections on the record. They don't have time to wait for another person to stand up, because if they wait, the question might be asked and the answer must have been solicited. No judge have the right to tell an attorney to not object. Not one. B. Judge Glanville has sustained spacious and frivolous vagueness and facts not in evidence arguments from the state that has effectively cut off the defense ability to conduct a thorough and sifting cross-examination. Just one example of this can be found by viewing undersigned counsel attempts to effectively cross-examine investigator Tyrone Dennis. D. Judge Glanville, on 2 different occasions, baselessly called Attorney Brian Steele unprofessional and unprepared in front of the sitting jury. When it was shown that Judge Glanville's comments were completely off base, Judge Glanville refused a defense request to issue an instruction that the juries should disregard his comments about Attorney Steele. Yeah, when that happened, that blew the top of me. That pissed me off royally. E. Judge Glanville has monitored the movements of defense counsel, including undersigned counsel, throughout the courthouse through security cameras for no permissible purpose and without cause. I'm reading this for the first time. Judge Glanville monitored movements of the defense attorneys without cause. You cannot and are not allowed to monitor movements in the courthouse. That, for you who don't know, I've been doing labor law for over 30 years. If I found out that an employer did this, I would have that company bankrupt, or made the choice to that company. That person, if that person is still here on Monday, I will fucking ruin you. I would say it without the F word, but you know what I mean. F. Speaking of F. The state has repeatedly demanded reciprocal discovery from the defense without any legal basis, and has repeatedly misstated the law covering reciprocal discovery, or to obtain an unfair advantage from Judge Glanville. The state has gone so far as to contact non-attorney members of the defense team and demand that they provide certain items to the state without consulting with defense counsel first. Yeah, we learned that this week, that the prosecution called the defense investigators in order to obtain information. Luckily, that investigators told the prosecution in no uncertain terms to go screw themselves. These actions were taken without any legal basis and were attempt to unconstitutionally invade the attorney-client privilege and the duty of confidentiality of the defense. G. The state intentionally and erroneously accused Attorney Steele of tampering and altering jail calls made by Kenneth Copeland, which was served in reciprocal discovery. Of course, these heavy accusations were entirely false and without merit. There were no consequences for making these wild, false claims. Yeah, and here's the thing with jail calls. The state has all of them. Now, if Mr. Steele, Attorney Steele, managed to find one of the thousands that is there, he has no duty towards the prosecution. None whatsoever. If the prosecution wants to find it, go find it. But the defense has zero obligation to help the prosecution prosecute. H. On June 10th, 2024, Judge Glanville held an illegal contempt hearing against attorney Brian Steele. Judge Glanville briefly incarcerated Mr. Steele and attempted to sentence him to 20 days in jail. Judge Glanville deprived attorney Steele of due process and the assistance of counsel. Oh, this is up to the Georgia Supreme Court. I don't think they have made a ruling yet. The defense, after repeated requests, have finally been provided with the state's June 7th, 2024, quote, ex parte motion for order to compel testimony necessary to the public interest, end quote. This motion, submitted by elected District Attorney Fannie Willis and Chief Deputy District Attorney Adrian Love, hereinafter Love, contains, upon information and belief, a glaring misrepresentation. In paragraph 11 of the motion, the state asserts that after an encounter with quote-unquote defense team members, Copeland informed representatives of the district attorney's office that, quote, he may attempt to plead the fifth in order to avoid testifying against members of the YSL, end quote. The motion does not provide any information regarding the specifics of this alleged encounter of which defense team members were allegedly involved. Upon information and belief, after reaching out to defense counsel involved in this case, this information is completely false. Upon information and belief, no members of any defense team had any contact with Kenneth Copeland on or about June 6, 2024. It goes without saying, upon information and belief, no defense counsel or members of any defense team ever interacted with Kenneth Copeland in any way that would dissuade him from testifying. This false and disparaging information about defense counsel was provided to Judge Glanville in an ex parte motion. Yeah, that was Miss Love and Miss Hilton lying. The June 10th, 2024 ex parte meeting. Let's see, 11. Except, quote, except as authorized by law or by rule, judges shall, not may, not maybe, not shall neither initiate nor consider ex parte communication by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of extraordinary matters, such as restraining orders and temporary injunctions. Here the state argues, well, we wanted to that immunity deal. You know how long it takes to give the judge a motion of immunity? Maybe 20 minutes to write the motion, hand it over to him, have a hearing about it in open court, and then it's done. Instead, there are two ex parte hearings we know about, and probably a third on the 6th or morning of the 7th. Probably even more with other witnesses. We don't know. In other judicial hearings, both parties should be notified of the hearing with an opportunity of any objection that may be properly registered. And here it is case law. Ex parte communications are presumed to be in error. Presumed. The baseline in law is that ex parte communications are in error. That is why everybody must be notified when one have happened, shall happen, or be in the meeting when it happens. Not like Judge Glanville trying to keep it a secret, and all of them a secret until after the trial. Additionally, the Georgia Code of Judicial Conduct 2.9 instructs judges to generally avert ex parte communications to assure fair hearings. Rule 2.9 generally permits ex parte communications subject to a narrow exception for, quote, scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that A, the judge reasonably believed that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. There's not a single person on this planet that can tell me that the prosecution didn't get a tactical advantage through Judge Glanville. There's not a single person. They can try to argue it to me, and I will tell them, go F yourself. B, the judge makes provisions promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. This is why I believe Judge Krause is completely out of line when claiming that nothing in the ex parte meeting was especially wrong. She didn't cite any case law to back her opinion up. Because if she had, they could show it. Now it's just an opinion there to save Judge Glanville. Number 12, on June 10th, 2024, while the defendants and defense attorneys were all in the trial courtroom waiting for court to start, Judge Glanville, Love, and/or Fulton County Deputy District Attorney Simon Hilton, hereinafter Hilton, as well as witness Kenneth Copeland, hereinafter Copeland, and his attorney Kayla Bumpus, hereinafter Bumpus, all met ex parte. Upon information and belief, this ex parte meeting was initiated by Love. Neither Copeland nor his attorneys requested this meeting. In fact, neither Copeland nor Bumpus ever expressed any concerns which would have prompted anyone to consider such a meeting at all appropriate. While the state falsely characterizes this meeting as merely a discussion about Copeland's grant of immunity, the reality is that Copeland had already been granted derivative use immunity on June 7th. There was nothing else for the parties to discuss regarding the grant of immunity. Copeland never requested to meet with the prosecutors and the trial judge to discuss these matters. Additionally, the ex parte communications were about more than Copeland's previously granted immunity. Judge Glanville and the prosecutors discussed Copeland's proposed testimony and provided legal advice, albeit incorrect legal advice, and strategy to Copeland. Throughout this process, Judge Glanville was clearly working in concert with the state and abandoned any semblance of impartiality. Number 14, neither Judge Glanville nor the state revealed that these ex parte communications has occurred to the defendants or defense counsel who were waiting for hours in the courtroom, completely oblivious to what was occurring behind closed doors. Judge Glanville's silence violated Georgia Code of Judicial Conduct 2.9 A1B. Melissa Babat here. Quick note, why is it not a problem for Hilton to go on vacation? Well, in my opinion, how they treated Mr. Melnick, it looks so planned from the prosecution to have Woody on the stand the 1 week they knew Mr. Melnick was out of town. And now Miss Hilton is going on vacation and says, please, court, allow me to go on vacation and Miss Love to ask questions to Copeland. Oh, really? Now it's okay? Now it's okay? I mean, I wouldn't be surprised if Miss Hilton's vacation is to a non-extradition country and she might stay there. I don't think it will happen. I'm just saying I wouldn't be surprised if that happens. 15. The defense would likely not know of these communications and the substance if not for attorney Brian Steele, who learned of the meeting by happenstance and confronted the court, bringing sunlight to darkness. 16. When attorney Steele inquired about the secret June 10th meeting, Judge Glanville immediately sought to hold attorney Brian Steele in contempt of court. And the wrong type of contempt of court. As it turned out, Judge Glanville doesn't know the difference between civil contempt and criminal contempt. He's been a judge for close to 30 years. And he doesn't know the difference between a civil contempt and a criminal contempt. And how many times have he used this? I presume hundreds of times, which all are evidence of Judge Glanville not being, he shouldn't be a judge. He shouldn't be a judge. 17, as the existence of the ex parte meeting became known, Judge Glanville, frustrated, undersigned counsel's attempt to learn more about this meeting, including undersigned counsel's repeated request for a transcript. Judge Glanville claimed that what occurred in this secret meeting in his chambers was privileged. This claim of privilege was without merit. Yeah, Judge Glanville lied to the court, or he doesn't know the rules. Whatever it is, it makes him unfit for his position. 18. Judge Glanville, it appears, instigated some sort of investigation into this incident. The focus of this investigation was not on the impropriety of the illegal meeting, but rather on how Attorney Steele and other members of the defense learned about it. This investigation included Judge Glanville utilizing law enforcement resources to access courthouse cameras to track the movements of Attorney Steele and undersigned counsel through the courthouse on June 10th. Holy fuck. I don't think Judge Glanville can do that without actually having a probable cause hearing, and that towards another judge. 19. As public pressure mounted, that would be me and you guys, a transcript of the meeting was eventually provided to the defense. The transcript of the meeting speaks for itself and is shocking. The transcript reveals that A, neither Love, Hilton, nor Judge Glanville had a legitimate basis to engage in ex parte communications. B, the ex parte meeting was not requested by Copeland or his attorney. C, the prosecutors, especially Love, misrepresented facts, also known as lie, and made spacious allegations against Attorney John Melnick, a hearing after Melnick, undersigned counsel and Attorney Steele to Judge Glanville. D, the prosecutors and Judge Glanville incorrectly advised Copeland about the law of derivative use immunity and applicable statute of limitations, all in an attempt to coerce Copeland to testify. And here are the footnotes. The details of these misrepresentations are discussed more fully in motions filed by attorneys Shardt, Steele, and Weinstein in motions filed July 23, 2024. The state claimed, and Judge Glanville ratified, that Copeland faces no legal jeopardy in this case by advising Copeland that the statute of limitations has run. It is unclear how state and the trial judge came to this conclusion. First, this conclusion ignores the tolling provisions of the statute of limitations in Georgia. Second, even for older incidents, the legal analysis interesting in light of the case that they are currently prosecuting and would be interesting to the 6 defendants in trial, those individuals who have entered pleas to this indictment, and those who continue to languish in jail awaiting trial on this indictment, as they are charged under a RICO count that includes cases dating back to January 25th, 2013. E, the prosecutors and Judge Glanville incorrectly advised Copeland that he could be held in civil contempt indefinitely if he failed to testify, all in an attempt to coerce Mr. Copeland to testify. F, Judge Glanville abandoned any semblance of neutrality and worked in concert with the prosecution by advising Mr. Copeland and Copeland's attorney about legal matters, all to cause Copeland to testify. G, Judge Glanville assisted the prosecution in preparation of Mr. Copeland as a state's witness, instructing that a list of questions prepared by the state be provided to him. I wish I was making this up. This is that there. List of questions prepared to the state be provided to the judge. This is communism, folks. This is communist court. Complete lack of due process, complete lack of rights. That, the G here, this is communism. I live in Sweden. This is a social democratic country, which is as close to communism as you can get. I hate communism. I have relatives died because of communism. I loathe communism. When I read this line here, I see the very courts that condemned some of my relatives to death in that line. And yeah, if you want to trigger me, call me a communist. Go fuck yourself if you do. H. A significant amount of Brady material poured out in this meeting, but the same was hidden from the defense. Neither the existence of this meeting nor this Brady material was revealed to the defense until the transcript was finally released. The June 7th ex parte meeting. On July 30, the Honorable Judge Whittaker presided over substantive matters of this case for the first time. The Honorable Judge Whittaker provided much-needed clarity to the defense by releasing the rough draft of a transcript of additional ex parte communications between the prosecution and Judge Glanville. This ex parte meeting occurred on June 7th and included Love, Hilton, and Judge Glanville. These communications and the substance thereof had never been disclosed to the defense until the Honorable Judge Whittaker released the transcript. Neither Judge Glanville nor the state ever made any disclosures regarding these communications, even as Attorney Steele pulled the curtain on the July 10th meeting. Instead, Judge Glanville and the state remained silent on this topic. Additionally, while the parties were well aware that the Honorable Judge Krause was considering the advisability and potential implication of June 10th, 2024, as part of her consideration of motions filed to recuse Judge Glanville upon information and belief, neither the prosecutors nor Judge Glanville ever revealed to Judge Krause that there was in fact another ex parte meeting that had occurred 3 days prior. This was their secret. 21. The transcript of June 7th, 2024 communications is shocking. It also sheds light on how this case has become irretrievably broken. As an initial matter, there is no stated justification for the ex parte communications. The meeting was initiated by the state. Neither Copeland nor his counsel had requested that the state meet in private with Judge Glanville. The meeting itself was illegal. The state in this meeting intentionally and wrongly attacked the character of Copeland's attorney Melnick, claiming that Melnick was not representing Copeland's interests. The prosecutors besmirched Melnick to Judge Glanville without cause, all because Copeland was not interacting with the prosecutors in a manner that they would have preferred. The prosecutors claimed to be the only ones who were truly representing the interest of, quote-unquote, our witness. The prosecutors complained that they had been having productive communications with Copeland outside the presence of Melnick before Mr. Melnick had, quote-unquote, inserted himself in his client's legal affairs. The prosecutors' claims that Melnick was not representing Copeland's interest is rich. As they were communicating with a person behind Melnick's back, the state had intended to call Mr. Copeland as a witness without granting him any sort of legal protection as a witness. For you who remember it, Hilton asserted in open court that she contacted Copeland directly. And I will submit to you, and several lawyers have stated the same as me, so I'm not out of line here. The last time the prosecution had dealing with Mr. Copeland, Mr. Melnick was his attorney. There was no information out there at all saying that had ceased to exist. The only information they had was that Mr. Melnick was still Woody's attorney, and they still contacted Woody directly. It was only after Melnick, quote-unquote, inserted himself and advocated for his client that the state sought to grant Copeland derivative use immunity. The irony does not end there. The state in this meeting claimed to be concerned about the possibility of Copeland suffering an unjust jail sentence due to Melnick's interference in his client's affairs. At no time, however, did the state ever seek any non-custodial alternatives of Copeland should Judge Glanville hold him in contempt. Instead, these prosecutors insisted on an indefinite incarceration for civil contempt, which would have been illegal. The state also questioned Melnick's devotion to his client, as Mr. Melnick was planning to leave the state on vacation while his client was incarcerated for contempt. The state complained to Judge Glanville that Melnick has not planned his vacation around Copeland's testimony. This is a ridiculous accusation, as the state intentionally failed to communicate with Melnick and had not given Melnick any notice that they were planning to call his client to testify on June 7th. And I will go even further. The prosecution knew that Mr. Melnick had planned this vacation. It was filed with this court. This is a long footnote. Footnote 8. While the state has maintained, at times at least, that they did not realize that Mr. Copeland was represented by Attorney Melnick when speaking to him, this excuse is difficult to accept. Their story also has changed. At times, they didn't know. At times, Melnick told them he didn't represent Copeland. At times, Copeland told that Melnick was not his attorney. At times, Copeland never asked to speak with Melnick. The explanations are all hard to accept. Love has prosecuted Mr. Copeland in case this, which was resolved on June 29, 2023. There you have it. Melnick represented Copeland on this case. Melnick's representation of Copeland is also openly discussed in interviews which were provided in discovery. Additionally, the fact that Melnick also represented Copeland's interest as a witness in this case was always fully understood by undersigned counsel, as Copeland faces legal exposure in this case. The defense has always acted appropriately and has refused to initiate any conversation with Copeland, who was known to be represented with Melnick, without Melnick's knowledge and approval. Melnick's representation of Copeland was no secret. Footnote 9. Upon information and belief, Attorney Melnick had already purchased non-refundable tickets for a trip to Alaska, which was to commence that coming weekend. Perhaps if the state has not cut out Melnick from their communications with his client, he would have been able to schedule his trip accordingly. We are on page 13, so we have, I don't know how much we have. Okay, the state was clearly only concerned with Copeland's interest as long as they were directly aligned with their own interest. The state feigned interest in Copeland's well-being to get a foot in the door to Judge Glanville's chambers, all in an attempt to initiate improper ex parte communications. 23. Melnick was not the only attorney who was disparaged by the state and Judge Glanville in this secret June 7th meeting. Love claimed that she was in receipt of an email from Melnick sent to her and Hilton, but also that other individuals had been quote-unquote blind copied on the communication. The clear insinuation from the conversation is that it was Attorney Steele and the undersigned counsel who were quote-unquote blind copied. Footnote 10. Love goes on to say that her immediate response to this email was to ask Melnick, whose, quote unquote, whose interests are you concerned about? Your clients or Mr. Steele and Mr. Shardt's? Undersigned counsel does not make bland accusations, but neither undersigned counsel nor Attorney Steele were, quote unquote, blind copied on any email between Love and Melnick. Later in the ex parte meeting, Love again brings up Attorney Steele and undersigned counsel, noting that we were included on a June 6, 2024 email from Melnick. Love and Hilton were also included in this email, in which Melnick expressed his client's decision to exercise his Fifth Amendment right if called to testify by the state. Footnote 11. Undersigned counsel confirms that this email was sent to Hilton, Love, undersigned counsel, and Steele, and asserts that there was nothing improper about this email. There is absolutely no requirement that Melnick limits his communications to the state, the very same people who excluded him from communications regarding his client. Shade! Love and Hilton was also included in this email in which Melnick expressed his client's decision to exercise his Fifth Amendment right is called to testify by the state. Footnote 11. Yeah. It is unknown why the Love feels. It is unknown why the Love. It is unknown why Love feels that she should have monopoly on information, or why she feels that defense attorneys should not be included on discussions concerning these matters. Undersigned counsel would like to inquiry about these matters with Love sworn in as a witness. 13 or something. Judge Glanville abandons any impartiality and echoes Love's thought, asking, quote unquote, why would he have done that given before ADA Hilton responds, quote, and that's the state's concern. Love then affirms that's the point. This is still a rough transcript. We don't have it all, not even from the 10th. As Judge Glanville had questions, so do I. Undersigned counsel asked why my inclusion on the simple email communication was of concern to the court. Love then assures Judge Glanville that she is looking for a remedy for this materially false and made-up situation, as if one exists, and tells Judge Glanville that she will contact him when she finds a solution, either over the weekend or on the coming Monday, presumably through additional ex parte communications. Footnote 12. It is unknown to undersigned counsel if the state and Judge Glanville had any further ex parte communication over that weekend, but we are now aware that an additional ex parte meeting occurred on the next Monday, June 10th. I would argue that there is clear evidence that there was also an ex parte meeting on the 6th or the morning of the 7th. Before wrapping up the illegal and unethical meeting, Judge Glanville refers to, quote unquote, outside agitators affecting the trial, stating, quote, I mean, but I see it from just being in the courtroom and tracking, end quote. Judge Glanville's concern and inherent skepticism of email communications between Melnick, Attorney Steele, and undersigned counsel exemplifies Judge Glanville's bias and partiality towards the state. The transcripts of both the June 7th and June 10th ex parte meetings show Judge Glanville's clear bias against Attorney Steele and undersigned counsel, and finally provide an explanation, albeit an acceptable one, for Judge Glanville's treatment of the defendants and their counsel throughout this trial. The illegality of the ex parte meetings now known to the defense. We now know that 2 ex parte meetings have occurred. These ex parte meetings were clearly illegal and improper. The state relies on King v. State in a spacious attempt to argue that these ex parte meetings were proper. The state reliance on King is misplaced for several reasons. First, in King, the state met with the court to provide information that would allow the court to make a judicial determination as to whether the anticipated testimony of the witness was, quote, necessary to the public interest, end quote, under OCGA 24-5-507, as is required under law. In this case, Judge Glanville had already conveyed derivative use immunity to Copeland earlier on June 7th, presumably in a third, albeit first in time, ex parte meeting. Yeah, this they knew about because they actually told them before Mr. Copeland took the stand that they had a meeting where the use immunity was granted. So that is public. That is not the third ex parte meeting I'm talking about. There is no indication that the witness was present for the meeting in King, while the actual forthcoming testimony expected of Copeland was openly discussed in Copeland's presence in the Star Chamber June 10th, 2024 meeting. Second, in King, the defense never alleged that they were not informed of the substance of the ex parte meeting in a timely manner. In our case, purposely hid this illegal and unethical conference from the defense. The fact that these meetings occurred, much less their substance, was only revealed due to the doggedness of the defense and sheer happenstance. Third, while the subject matter was limited to, quote-unquote, necessary to the public interest, requirement of OCGA 24-5-507 in King, the subject matter of the June 7th and June 10th ex parte meetings included much more, including spacious and knowingly false allegations made against defense counsel and by relations the defendants themselves. 25. These improper ex parte meetings are the result of both grave prosecutorial and judicial misconduct. These meetings were never requested by Copeland, Bumpus, or Melnick. Instead, they were all initiated by the state and welcomed by Judge Glanville. These meetings, when considered with other previously discussed actions of the prosecutors and Judge Glanville in this case, violated Mr. Stillwell's constitutional rights to due process and a fair trial. 26. These meetings, especially when considered in addition to Judge Glanville's other actions throughout this trial, have also violated Mr. Stillwell's right to a fair trial in front of an impartial judge. The transcript of these meetings revealed that Judge Glanville, perhaps based on inaccurate and misleading information provided to him by the prosecutors through ex parte communications, always looked at Attorney Steele and undersigned counsel, as well as our respected clients, with suspicion. Judge Glanville, in meeting with, consulting with, working with, and planning with the prosecutors, clearly abandoned any semblance of impartiality. 27. Both these meetings occurred during critical stages in this trial. Mr. Stillwell had a constitutional right to be present. See Article 1, Section 1, Paragraph 12 of the Georgia Constitution and the corresponding section of the United States Constitution, backed up by Scudder v. State, 298 Georgia 438 440 2016. As Mr. Stillwell nor his counsel were permitted to attend these meetings, Mr. Stillwell's 6th and 14th Amendment rights of the United States Constitution, as well as Article 1, Section 1, Paragraph 12 of the Georgia Constitution, were violated. This is a structural error which will demand reversal, should Mr. Stillwell be wrongfully convicted of any counts in this indictment. Remedies. Now let's see what they asked for. Mr. Stillwell has been harmed by judicial misconduct, prosecutorial misconduct, and other error in this case. Focusing solely on the ex parte communications, the prosecutors and the trial judge teamed up to coerce and intimidate Copeland to change his mind and testify for the state. Copeland's testimony was harmful in itself, but does more than that. As a result of this coercion and intimidation, the state has and plans to continue to impeach Copeland with his prior inconsistent statement, essentially playing several videos of Copeland's out-of-court statements, which are harmful and prejudicial to Mr. Stillwell and others. These out-of-court statements involve several of the charged events and counts in this indictment and are central to count 2 of this indictment, which alleges Mr. Stillwell committed the murder of Donovan Thomas. 29. Mr. Stillwell does not wish to demand a mistrial, absent finding of goading, and thus jeopardy attaching. Mr. Stillwell has been incarcerated throughout the duration of this case. He has been viciously attacked while incarcerated. He almost lost his life. Yeah, Mr. Stillwell was stabbed just before Christmas and was in the infirmary for weeks. Starting trial all over again is not a viable option for Mr. Stillwell. Despite persistent legal errors, the illegal actions taken by the prosecutors and the previous trial judge, and the damage inflicted by the presentation of Copeland's prior untruthful out-of-court statements, the defense is winning. Additionally, this trial is already tainted by structural errors. Mr. Stillwell does not wish to submit to the desires of the state and Judge Lavelle, who have attempted to goad Mr. Stillwell into moving for a mistrial. Mr. Stillwell does not want this case to start all over. 30. Nonetheless, serious errors have tainted this trial. It is unacceptable that Mr. Stillwell must accept that the first several months of this trial have been tainted by prosecutorial and judicial misconduct, illegal ex parte meetings, and partial judge. It is unacceptable that Copeland's out-of-court statements, which are arguably admissible as a result of the previously discussed illegal ex parte meeting, may be played for the jury. It is also unacceptable that the previous rulings of a partial judge should continue to guide this case. Judge Glanville's hostility towards and suspicion of undersigned counsel has likely created a lasting impression on the jury. We surely view a trial judge as a person in authority. Carrying on with this trial as if nothing improper has occurred is not an acceptable option. 31. The structural errors and other legal reversible errors in this case must be considered in the context of how they occurred. All of these errors have been caused by the prosecution and Judge Glanville. Neither Mr. Stillwell, undersigned counsel, nor any co-defendants or their counsel have caused or invited any of these issues. Hilton is a seasoned prosecutor of nearly 15 years who holds the title of Deputy District Attorney in the Fulton County District Attorney's Office. Per the District Attorney's website, she helps lead the Special Victims Division. She has received many awards with the District Attorney's Office and has also taught trial technique classes at Emory University School of Law. Next class should be how to not conduct themselves in a trial. Love is an attorney with almost 20 years of litigation experience, almost exclusively as a prosecutor. Attorney Love is a Chief Deputy District Attorney of the high-profile cases and difficult witnesses division within the Fulton County District Attorney's Office and is part of the office's executive team. She leads a division in the largest district attorney's office in the state, one that is dedicated to cases involving quote-unquote difficult witnesses. Now we know how she handles it. By being a C word. The Georgia Court of Appeals has noted that, quote, state prosecutors are generally knowledgeable and well-trained, end quote. Too knowledgeable and well-trained not to know the consequences of basic rules of prosecutorial procedure and conduct. Wilson v. State, Georgia App, 1998. Prosecutors, as recognized and experienced by Hilton and Love, should certainly be held to this minimal bar, if not much higher. Surely Hilton and Love, with the knowledge and experience, know the impropriety of these ex parte communications. And that is why I believe they actually thought these two on the record were proper. That is why they were held with a court reporter. I honestly believe that's the reason why we are actually knowing about them. Because I believe there were many others not on the record. Their experience told them something else, however. Based on the knowledge of the law of impeachment and prior inconsistent statements, the prosecutors knew that if Copeland did not testify and remain in jail, Even a partial judge will be hard-pressed to allow the jurors to hear the multiple hours of Copeland's recorded statements. The ex parte meeting was a calculated risk for the prosecutors. Either Copeland would be intimidated and coerced into testifying, or the illegal ex parte communications would be grounds for a mistrial and the state would have time to regroup and begin anew. Judge Glanville currently serves as the chief judge in Fulton County Superior Court. Per the Fulton County Superior Court website, he has been a lawyer for 37 years and has served as a judge for 29 years, 19 of which as a Superior Court judge in Fulton County. Judge Glanville knows the rules concerning ex parte communications, both in the Uniform Rules of Superior Court and in the Georgia Code of Judicial Conduct. He should know, but we'll also know that he doesn't know the difference between civil contempt and criminal contempt. Based on the experience of prosecutors Hilton and Love, as well as the experience of Judge Glanville, the notion that the decision to hold these repeated secret illegal and unethical ex parte meetings were due to inexperience or simple lapses in judgment does not pass any test, including the smell test, I assume. These were conscious decisions to secretly violate the most basic of Mr. Stillwell's constitutional rights. Several factors in this case, including the prosecutors and trial judges' wealth of experience, the egregiousness of prosecutorial and judicial misconduct, the fact that the evidence presented so far has been far from overwhelming, the structural and reversible error already baked into this case, and the repeated violation of these rules all clearly support a finding that their actions were intentional and designed to goad a mistrial. Case law. Conclusion. This case is constitutionally and legally broken at this time. Mr. Stillwell is not requesting a mistrial absent finding of goading, but appropriate remedies must exist. Possible remedies include, but are not limited to, disqualification of the prosecutors involved in this misconduct. Judge Glanville has already been recused. The dismissal of this indictment with prejudice, instructing the sitting jury that explanation the situation in full candor, and or mistrial with a finding that a mistrial caused by judicial and prosecutorial misconduct, and the defense was goaded into any such request. Wherefore, undersigned counsel respectfully requests this court consider Mr. Stillwell's argument and issue an order which will fully and adequately protect Mr. Stillwell's constitutional right. The 2nd day of August 2024. Respectfully submitted, Max Shardt. And certificate of service. Ooh, that took a while. I was hoping most of it would be attachment, but it was all in the motion. Wow. Yeah. I mean, Judge Whittaker, I do believe that Judge Whittaker will deny this. She shouldn't, but she will deny it. But it is important to have all of this protected for appeal. That's the reason. Now, Mr. Weinstein's is formulated differently. And I believe that is why Judge Whittaker has such a hard time motivating a ruling against it. So it will be really interesting. And now when the defense attorneys have filed this additional one, I don't think Judge Whittaker can make a ruling this weekend without accepting Melnick's testimony either in written form or in open court. Because the accusations from the prosecution is too much to ignore. If they lied not only in ex parte meetings, they lied in open court. They told this judge there was no other ex parte meetings other than a 10th, and they lied to her.